Welcome to the Legal Shark Tank, Strategies for DUI and Beyond with Shane the Shark, where we'll discuss the complexities of the legal system, demystify the process of criminal defense, and provide you with the tools and confidence to navigate your case.
Welcome to the Legal Shark Tank, Strategies for DUI and Beyond with Shane Herzner. I'm Sam Henninger, and I'm excited to talk with Shane today. We're just going to get started because, Shane, I really want to set the stage and you just explain what your journey has been in becoming a DUI law expert.
Sure. It's kind of a four-part journey, believe it or not. When I graduated from law school, I originally did civil work, which had nothing to do at all with the type of work I do right now. But with that civil work, I didn't get to do a lot of courtroom work. And that's the part of law school that I enjoyed the most, was the actual courtroom stuff and courtroom practice. So I did civil work for about 3 years before I got offered a position at the Hamilton County Prosecutor's Office as an Assistant Prosecutor. And with an opportunity like that, I couldn't pass it up. It was a major pay cut, but I did take that in order to practice in the criminal realm. After practicing as an assistant prosecutor for about 5 years, I went into private practice. So that was kind of the third tier of my journey. I was on my own for a little bit, and another criminal defense attorney hired me to work at his practice, and he predominantly did DUI work. So that's a little bit of the background on how I got involved into the DUI realm. I was looking for another challenge, though, because I wanted to run my own ship and see what things I could do as far as helping people out. So I started my own practice back in 2013, and I've been practicing predominantly DUI defense ever since then.
Tell us more about that shift you made, helping out with more DUI cases, and then when you decided to go your own way and start working in that space. Tell me about that journey and what interests you about practicing law in that space.
I think that doing defense work is much more challenging. I think that's what attracted me more to doing it than staying with the prosecutor's office. Because trust me, I really loved it. My experience at the prosecutor's office was wonderful. I got to try a lot of cases, a wide variety of cases. One of the things that I found in criminal defense, though, is that I don't want to say the odds are against you, but it seems like everybody automatically assumes your client is guilty. And so that's a challenging part that you have to take on. And I like that part. I also like being able to help people. And I think I can help people more on the criminal defense side, specifically DUI, than what I could at the prosecutor's office. So once I started doing DUI defense, it's kind of a niche practice. Not a lot of people do it predominantly. Some people dabble in DUI defense, but quite frankly, you really have to know what you're doing on DUI defense to properly represent a client. There's so many minor details about a DUI case and the practice, and laws are constantly changing with DUI defense, that you almost have to concentrate your practice in that area in order to properly represent someone on a DUI case.
Well, and you mentioned how when defending in such cases, a lot of people just assume the client's guilty already. Tell me more about why you think that is and what other challenges come up for you when you're defending your clients.
I think it's just natural for somebody to assume, well, you had something to drink and the officer has to be right because the officer performed these standardized field sobriety tests and the officer knows better. And he's taken a drunk driver off the road that could hurt somebody. So I think the natural inclination from the get-go is that the person must be guilty. However, I've seen so many cases where officers are either overzealous or even a person going to a holiday party and maybe having one too many drinks while at the holiday party still has the right to a proper defense. They still have the right to potentially getting that charge reduced. So those are the types of clients that we predominantly represent. You hear all the time about a person receiving multiple DUIs. That doesn't happen nearly as often as you would think. Most of our clients, the overwhelming majority, are first-time offenders. Again, that person who has maybe one too many drinks at a cocktail party or goes after work to the happy hour. Those are the type of clients that we get the majority of the time. Or we'll get some clients, and hopefully we'll be able to talk about it later, who haven't had anything at all to drink and still register on these breath alcohol machines. So there's a wide variety of clients that we represent, and I think everybody's entitled to a zealous representation, and that's why I like the challenging part of this job.
Well, I hear that. I hear the challenge that you enjoy and the card sort of being stacked against most people who have these sorts of cases, offenses brought toward them. Walk us through a particular case that you've successfully defended, because I think that'd be really interesting to hear, as there are, I'm sure, listeners who know someone or maybe have even been one of those first-time offenders and wonder, is there anything else to do than to just take it on the chin? Is there such a thing as successful defense?
Absolutely, there is. One client that I always remember, he owned laundromats, and he would do clean clothes. And the chemicals that he would work with on a daily basis were alcohol-based. They were not ethyl alcohol-based, but they were alcohol-based chemicals. And he was breathing these chemicals in every day when he was at work. Wasn't drinking on this particular night that he was pulled over, but when he took the breath test, because of those chemicals being breathed into his system, he actually tested positive on one of the breath testing machines. Fortunately for him, we were able to get an expert witness to testify at court and showed the court, because this was a bench trial, not a jury trial, showed the court that even if he hadn't had anything at all to drink on a particular day, he could blow into this breath testing machine and test positive for alcohol when he never ever consumed alcohol. The particular machine that he was blowing into didn't, they do infrared reading of the alcohol when you blow into the machine, and it wasn't able to differentiate those chemicals that he was using from ethyl alcohol. And that's why it was shown as a positive. Now, fortunately for him, we were able to take the case to trial, and he was found not guilty by the judge. But some people do not have the financial ability to hire these expert witnesses. So I do everything in our power to try to work those cases to where we can still help the client and get the best possible results for them. But just because somebody tests positive on these alcohol machines, there's oftentimes reasons for that. There's oftentimes reasons for a person to test an elevated level for alcohol as well.
Shane, what I'm hearing from your description is that these machines, which the law enforcement use to determine sobriety, they're not 100% reliable. And that can often play a big part or a significant part in some of the cases that you've taken on. Would you mind explaining what these machines are and how that factors into you building your defense?
In Ohio, we are not able to challenge the general reliability of breath testing machines. Believe it or not, we're one of the few states that you can't. Some states you're able to call an expert witness no matter what machine they blow on, and the expert witness can testify to issues with a wide array of problems with these breath testing machines. In Ohio, you can't. So you have to find the specific machine that they blew on and find an issue with that, or find other issues, like I said, such as the case example that I gave you. It's often challenging to do that because the Ohio Department of Health dictates which machines are reliable and which machines aren't. I remember going to a seminar once where the presenter held up a juice box with a straw in it. And he said that if the Ohio Department of Health approves this juice box as being a reliable breath testing machine, that would be considered a reliable breath testing machine. Most of these machines, too, are decades old. It's amazing that some of these machines are still in operation from the 80s, 90s, even some of the newer breath testing machines. I remember back in 2010 when the Intoxalizer 8000 was the new machine that came and was approved by the Department of Health. And it was a dual testing machine, which was something different than the prior machines in Ohio. So it actually had a client or a person blow into the machine twice, and they would take the lower of the two breath tests. And that's what would determine what their BAC was. There are a lot of issues with this particular machine, and there are several departments that don't even use that machine. Now they're talking about a new machine, and I believe that some departments already have it. It's the Intoxalizer 9000. So I'm interested in finding out all the different issues that come about as a result of that machine, because these manufacturers now, The older machines were able to get some of the information. You could actually take classes to learn how to operate these machines. The newer machines, they're not allowing defense attorneys any of the source code information or any of the scientific information that they use to determine what a person's BAC is. So there's a lot of issues not only with the older machines, which I think are kind of outdated now, and the new machines where they're not sharing information with defense attorneys, which makes it difficult for us to challenge them.
Well, Intoxalizer 9000, it sounds like something out of a comic book, but here we are.
You should see it. It looks like something out of a comic book. It's like a suitcase, and it doesn't look like anything modern that you would think is reliable. I couldn't tell you how many stories that clients have told me that they blew into the machine and it looked like it was something out of the 1980s. And I told them, well, there's a chance that it could very well have been from the 1980s.
Thinking to, again, just this timeline, this overall perspective, I'm curious how else you've seen laws evolve around the way you practice and how you've adapted.
There's a joke among us attorneys that practice DUI defense primarily is every time we find an issue with these machines or a way to beat the state, somehow the legislature comes up with legislation that kind of kills that defense. So we're constantly evolving because we do have to find new and different ways to challenge not only the breath testing machines, but also the standardized field sobriety testing, which seems to change every time that we find I hate calling them loopholes, but every time we find an issue or a question of the reliability of them, they always come up with something, some new legislation or some update that either mitigates that defense or takes it away completely.
And to get back to maybe a broader question, I'm sure a lot of listeners are curious how you actually go about building a strong defense and what those conversations and questions tend to look like at the beginning.
My major concern when I first get a client is getting them driving privileges, because their license, if they take a chemical test and they are over the per se limit, which is an 08 in every state except Utah, I believe is an 05 now. And if you refuse, your license gets suspended. So they're dealing with that issue, and you don't realize how much you drive every single day until you don't have your ability to drive. And so now it's causing stress on the family to get your kids to school or get to work, things like that. So that's usually my first step in a case is at the arraignment, try to figure out when they're eligible for driving privileges, whether it's after 15 days or after 30 days, and then get them those driving privileges as soon as possible. So that'll alleviate some of the stress off the client. After that, then there are several pre-trials most of the time so that we can get the police reports, the videos, and all the other discovery information. That's what we call it. We call it discovery, and that's essentially the state's case. What information do they have? Once I get that discovery information, I like to meet with clients, because the only way a client can make a good educational decision on how to proceed on a case is if they have the same information that I have. So I try to provide them with all that information. I give them copies of all the police reports that I'm able to. And on the videos, if I'm able to show them the video, I bring them into my conference room and we go over the video. The reason why I do the video in person is I think it's important to break down the video into certain parts based off of what the officer is looking at for certain parts, such as vehicle in motion, the stopping sequence, personal contact. Those things I like to break down with the client, go over with the client what my thoughts are on the discovery, what my concerns are, what I think is good concerning the discovery, and then present the client their different options as far as moving forward. I don't like to make the decision for the client because each case has a different result for a particular client. Some clients don't want any license suspension at all. Some clients are saying, hey, just minimize as much as you can. So you got a wide array, and each client will ask you for something different than other clients. So once I present the client with those particular options and they tell me what they want to do, then we'll either set the case for a plea or for trial. But I try not to push a client one way or another or tell a client that they need to do this or do that unless I definitely believe that they're making a bad decision or doing something that I think could be to their detriment.
That's a wonderful way to put it. And most people who have never been in contact with a lawyer, never needed to hire a lawyer, getting a sense of what those first conversations or the first, handful of weeks or whatever may look like, that could be a great comfort to people to have a sense of how it works.
Yeah, I agree. I think it's important for them. I think you really said it when you said comfort, because it's a stressful situation. I can't emphasize that enough. And so anything that I could do to comfort the client, I absolutely will do. Try to walk them through the entire process, what they could expect. And all my clients have my cell number. They all have my personal cell number. It's not a secret. They can call me, they can text me, because I don't work banker hours. So I'm not only answering the phone 9 to 5, because people have questions beyond 5 o'clock and they have questions before 9 a.m. So I'm always happy to answer questions for clients or text them, because you will get some clients that will text you almost every day and some clients you'll never hear from. So you have to be able to adapt to how often the client needs to have contact in order to feel comfortable.
Would you mind just walking us through what precisely is meant by a standardized field sobriety test?
Yeah, the standardized field sobriety tests are a set of tests that the National Highway Traffic Safety Administration has determined are reliable tests to determine if somebody has a BAC. Now it's changed to an 08, but the original tests were to determine if somebody was above a BAC of a 0.10, because that's what the BAC, national BAC used to be. Everybody had it as a 10. These tests consist of the horizontal gaze nystagmus test, which most people refer to as the PIN test or the eye test. There's the walk and turn test, and there's the one leg stand test. When they have a person go through these tests, what they're looking for are certain cues or clues that they determine to help them to decide if a person is under the influence of alcohol or not. Now, I always tell clients there are several reasons why a person may perform poorly on these standardized field sobriety tests that have nothing to do with alcohol at all. And as a matter of fact, these standardized field sobriety tests are optional. You don't have to do them. And I tell clients, don't do them. That's one thing you always hear about the breath test being optional. You don't have to take that. But no one gets it out there enough that these standardized field sobriety tests are optional too. And if an officer is asking you to get out of the vehicle to perform standardized field sobriety tests, chances are they've already made the decision to arrest you for a DUI or OVI is what we call them in Ohio.
What information, I'm wary now of saying, what advice do you have? Because I know that means something particular for lawyers, but what information would you offer for listeners when it comes to being charged with a DUI or being suspected of one?
First and foremost, I think if you've had something to drink or you feel that you've had too much to drink, get a cab, get an Uber. There's so many resources out there nowadays that you should use, because an Uber, Lyft, or a cab is a heck of a lot cheaper than me. And it's a lot cheaper than the court cost and other expenses that you may incur as a result of a traffic stop for an OVI. But as far as if you are in that situation where you are being pulled over for an OVI, I always tell clients, you don't have to make any admissions. Don't lie to the officer. If he asks you how much you've had to drink, you could be either, I recommend not answering the question or tell them you would like to speak to an attorney first. But I would never tell them you haven't had anything, because I think that's a bad first step with the officer. And if a jury doesn't believe you when you answer that question, it's going to be very, very difficult to convince them on other things that you're saying to them as being truthful. So you're better off either not answering that question or telling them that you want to speak to an attorney before you answer those questions. Don't do any of the standardized field sobriety testing, and don't do a breath test. Those are the best pieces of advice that I can give a client. And the less you talk, the better. So stay quiet, only give them identifying information. They ask you to get out of the car. You do have to get out of the car. Don't fight them on that, because they will get you out of the car. Probably not the way that you want to get out of the car. So cooperate with them with that and give them your identifying information, driver's license, things like that. But as far as answering questions on how much have you had to drink, where are you coming from, those type of questions, I would advise you to tell them that you want to speak to an attorney before answering any.
This has been the Legal Shark Tank, Strategies for DUI and Beyond with Shane Herzner. I'm Sam Henninger. Thank you for listening. Please like, follow, subscribe, share, because we're going to continue having these great conversations with Shane. Thank you, Shane.
Thanks, Sam.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.